problems in mergers and acquisitions. Our presenters this afternoon are Ilene Ferenzi and Tim McCutcheon. Ilene is the managing partner of Ferenzi Benefits Law Center, LLP, in Atlanta, Georgia. She advises clients on all types of employee benefit plans, particularly focusing her practice on qualified retirement plans, benefit issues in mergers and acquisitions, and advising third-party administrators of employee benefits programs on technical and practice issues. Having become an attorney after more than 10 years as a third-party administrator, Ilene brings a unique and practical approach to her advice. She is a member of the state bars of Georgia and California and holds designations as Certified Pension Consultant from ASPA and Accredited Pension Administrator from NIPA. Ilene is also the author of the Qualified Plan eSource on ERISApedia.com. Tim is the publisher of ERISApedia.com and was the founder of ftwilliam.com, the most innovative document and government forms provider in the industry. He wrote the first web-based 5500 forms package and introduced the first retirement plan document e-sign system. Prior to founding ERISApedia.com and ftwilliam.com, Tim's law practice included counseling third-party administrators, financial service companies, and other benefit service providers regarding qualified plan, product design, and compliance. Tim received his JD from the University of Wisconsin-Madison and his MBA from Kellogg School of Management at Northwestern University. He is a member of the IRS Great Lakes TEGE Council and a former member of the Information Reporting Program Advisory Committee of the IRS. We are very excited to have both Ilene and Tim with us today. My name is Maureen Pesic, and I will be facilitating this webinar. Also with us today is Joanne Pacina, who will be monitoring the questions. We have a few housekeeping notes before we begin. All attendees' lines are muted. If you would like to ask a question, please type it into the GoToWebinar dashboard in the questions section. With Joanne's help, Ilene will try to get to as many as she can during the webinar. A copy of the slides can be downloaded also from the GoToWebinar dashboard. Look for them in the Handouts section. The slides are also available on ERISApedia.com. Just click on the Webcasts tab. This webinar is being recorded. A copy of the webinar will be available on ERISApedia.com on the Webcast tab in a few days. And CE credits will be sent to the email address you registered with. ASPA and NIPA credits will be mailed in a few days. IRPA credits take a little bit longer, so please be patient and be sure to check your spam folder. At the conclusion of the webinar, I will stay on the line for a quick demonstration of Ilene's Qualified Plan eSource title on ERISApedia.com. I will quickly show you the detailed information that can be found on merger and acquisition issues. The demo is voluntary and will take just a few minutes. And now, without further ado, Ilene and Tim.
Good afternoon, everybody. How you doing, Tim?
I am doing well, thank you.
Good. Okay, so here's our agenda for today. In order to talk about the coverage rules and the transition period, we really need to do sort of a quick 410B primer. So we're going to do that. We're also going to do sort of a quick primer on M&A and what happens to employees in various transactions. We're going to talk a little bit about the service crediting rules because that's also important to who gets covered and when. And then with that, we're going to talk about what happens when transactions occur and how the grace period, the transition period, can help you deal with those things. And then finally, we'll talk about some transition rule fine points. So moving on to our next slide. We're going to start with our 410B primer. And again, for those of you who are 410B gurus, please forgive me. Just sort of, put your head down on the desk and pretend to listen while we go through this part. So let's talk first. What 410B does is it deals with plan coverage. And what we mean by that is, are the employees that are covered in the plan, do they represent a fair cross-section of the employees? Coverage has nothing to do, generally speaking, with the amount of benefit. It only has to do with whether or not the folks that are in the plan represent a fair cross-section of employees. If we had a situation that we were covering just highly compensated employees, then the plan would not consider to be broad-based enough, and it would fail the qualification requirement. Next slide, please. So there are several ways to meet the 410B rules. The first one is the most common, and it's the easiest to do. It's the ratio percentage test, which we refer to throughout as the RPT. It is very approachable, and we're going to go through doing that as part of all this. The second test is the average benefits test. It's much more complex. You need to have somebody who understands a lot more about some of the various technical rules and calculations to do that. And then finally, there's the qualified separate lines of business rules, or the QSLOB rules, which allow you to treat various parts of the company as if they were separate companies. I will tell you that I get asked to do QSLOB studies periodically. It very rarely is of help. So if you've sort of been slobbering, pardon the pun, with the idea of someday doing a QSLOB and having that, I will tell you it works really, really rarely. When it works, it helps, but when it doesn't, it's just it's a lot of energy for very little payoff. So if you've never dealt with a QSLOB, you're not that unique. Next slide, please. So basically, the rule about 410B is that enough employees must be benefiting to meet one of the tests. And so the next question is, what constitutes benefiting? And it's really important to understand that what constitutes benefiting for purposes of 410B is different depending upon the kind of plan and the kind of portion of the benefit that we're talking about. So for a defined benefit plan, in order to be considered to be benefiting, you actually have to accrue a benefit, which means that your benefit, as of the end of the year has to be higher than it was as of the beginning of the year. In a money purchase or profit sharing plan, you benefit if you actually get an allocation of contribution or forfeiture. So again, it's not an earnings issue, but if you get an allocation of contribution or forfeitures, your account's going up because of new money coming in, that constitutes benefiting. Now, in the 401 side, I'm sorry, go ahead.
If I get an allocation of 10 bucks, am I benefiting?
Technically, yes, although there is some concern about situations where you put somebody in the plan in order to pass 410B and you give them a teeny tiny benefit. There are rules about that where they say there has to be some substance to the benefit. But technically, if we did a $1,000 allocation to the plan that year so that everybody in the plan got teeny tiny amounts and your $10 was proportionate to what everybody else got, I think that you would still be benefiting. Do you agree with that, Tim?
Yes, definitely.
Okay, good. Okay. Now, on the 401k side, because so much of the rule is dependent upon what the employee, him or herself, decides to do, what you look at is whether or not somebody would be allowed to defer if they wanted to do so. So if you are able to defer if you want to do so, then you're benefiting, whether you actually defer or not. Because again, this has to do with what the plan is making available, not necessarily with what people are doing. And similarly for a match, the question is, would you get a match if you did defer, whether you deferred or not? So if I have a situation where somebody would not get a match, even though they did defer, that person would not be benefiting. Moving on, please. So let's talk very quickly about the procedure that we do for 410B, particularly under the ratio percentage test. The important thing is that we have to start with all the employees of the employer, and the employer in that circumstance includes all of the controlled or affiliated service group. So you start with this big group of people that is involved with the company who's sponsoring the plan and every other company that's related to it. We then subtract out what we call excluded employees. And excluded employees are not necessarily the employees that are not in the plan. They are people who are allowed to be excluded from the testing itself. And that includes people who do not meet the minimum age and service requirements. It includes collectively bargained employees to the extent that unions, the collective bargaining negotiations included a discussion of benefits. Next slide, please. The excluded employees also include non-resident aliens with no U.S. source income. And I just really want to emphasize that Americans abroad are not non-resident aliens, nor are people who are not U.S. citizens who are living in the United States. We're talking about people who are not U.S. citizens and who are living abroad and therefore have no U.S. source income at all. Once you cover any non-resident aliens, however, these people cease to become excluded employees, and you have to count them in your coverage test. And then finally, probably the most complex part of this whole test is that some terminated employees are allowed to be excluded. Those include people who do not benefit under the plan during the year, who are otherwise eligible to participate. In other words, they've met age and service requirements. They do not meet the plan's minimum service requirement for allocations, such as the 1,000-hour rule or the last day rule. So there's a reason why they're not getting an allocation that relates to whether or not they're there at the end of the year or how many hours they work. And they also have 500 or fewer hours during the year. So if you have somebody who terminates employment during the year and they're not going to get a contribution because they're not there at year end, and they had, like I said, 400 hours during that year, that person would be excludable from the ratio percentage test. But a person that terminates employment with 800 hours during the year who won't get a contribution that year is not excludable. Next slide, please. Once you figure out who is in the testing group, then you divide that testing group into two sections, the one for HCEs and the one for NHCEs. So you're going to look from this point on at simply the HCE group by itself and the NHCE group by itself. You take a fraction for each of these categories where the numerator of the fraction are the employees in that group who benefit, and the denominator is the total non-excluded employees in that group. So again, we started out with the total employees in the company. We subtracted out the excludable people. We came down to the testing group. We divided up that testing group between HCEs and NHCEs. Looking at the HCE group, let's say that we have 50 people in the HCE group, and of those 50, 25 people are actually benefiting under the plan, meaning they have the ability to participate in the plan, either make contributions to the 401k side or get a matching contribution or get a profit sharing allocation or whatever. We divide that by the total employees in the group in that category. So it would be 25 over 50, and the fraction for that gives us 50%, and then the NHCE fraction has to be at least 70% of that HCE fraction. So in my illustration, 70% of 50% would be 35%. The ABT, the second test, is much more complex, as I mentioned. It has two parts to it. The first part is the non-discriminatory classification test, which in itself has two parts. The first part is that the plan has to cover a reasonable classification, which is a little bit touchy-feely. You can base it on any kind of reasonable business classification, such as the type of job. We're just going to cover attorneys in this plan. We're just going to cover attorneys and paralegals. We're just going to cover nurses in this plan. Whatever it is, some sort of job classification. It can be based on the type of compensation. We're just going to cover hourly people. We're just going to cover salaried people, something like that. Geographic location, we're just going to cover our Atlanta office, so we're going to exclude the California office, or some similar bona fide business criteria. What you cannot do for purposes of this test is exclude people by name or by classifications that have, quote unquote, substantially the same effect as excluding people by name. So if, for example, you only have doctors who are partners, by saying we're going to exclude everybody who's not a partner, that's pretty similar to excluding people by name in a very small company. We're not studying 410B in this session. We're really doing this as a precursor to studying M&A, but you could spend hours on what constitutes a classification having a substantially similar effect, and there's been a lot of discussion about that over the past couple of years. The second part of the non-discriminatory classification test is once you have a reasonable classification, then when you calculate that fraction that we talked about before, the ratio percentage fraction, rather than having to meet 70%, the unsafe harbor percentage is between 20 and 40%. So basically, your test as to whether or not this part of the test is passed is easier to pass than a normal ratio percentage test. Next slide, please. And then the second part of the average benefit test looks at the average rate of benefits for HCEs versus non-HCEs. And what's interesting about this section, and again, we're not necessarily studying 410B in its total, so I'm not going to spend a lot of time on it, but that it looks at all of the benefits in all of the plans of the employer. So even though we're only testing this plan, this part of the test draws in other plans of the employer. Next slide, please.
Ilene, if I can just pop in with a quick question on what you're talking about right now. Someone's asked, can't you exclude using names if using a volume submitter document?
It depends. You certainly can under certain circumstances. What I think the person is talking about here is you're using cross-testing to meet your non-discrimination testing, and there's limits as to or I shouldn't say, let me rephrase this. When you're using cross-testing, part of the cross-testing process is to use part of the average benefit testing process. The part of the average benefit testing process that you use for cross-testing does not include the portion of the average benefit test that talks about having a reasonable classification. So that rule is not an issue with your general testing, with your cross-testing, the way it is with average benefit testing.
Okay.
So it is a different purpose that you're worried about there than is just the regular average benefit testing. Okay?
Thank you.
So, okay. If all non-excluded employees benefit under the plan, then obviously the ratio percentage test becomes 100%, and the 410B test is automatically met. So if you have a plan that covers everybody in all of the companies that are part of the controlled or affiliated service group that meet age and service requirements, for example, you will automatically meet the ratio percentage test, and you're just done. I mean, if you're covering everybody, you're just done. And in fact, 410B is not an issue there because you're not excluding any groups. Okay, it's only really when you're carving out some groups of people that 410B becomes an issue. The RVT test is also passed as long as, and there's an error in this sentence. I typed it incorrectly, so let me just tell you to fix it on your copy. The RVT is passed so long as the percentage of non-excluded NHCEs is 30%. No, actually that is right. It's 30% or less. In other words, you take your NHCEs, you can carve out 30% of those, and then you'll still have a ratio percentage of 70%. Excuse me, I just read it wrong when I was reading it. So if I have 10 rank and file employees and I just exclude 3 of them, however I want to exclude them, it doesn't really make any difference as long as it's not a racial or other, something that violates the regular, sex and race and everything else discrimination rules of the Constitution, then I will automatically meet testing. So I can just exclude 3 people off the 10 willy-nilly every year, and I'll still meet the coverage testing. Next slide, please. In addition to that, if none of the HCEs benefit, then my HCE percentage is always 0. Therefore, whatever the percentage is for the non-HCEs will be fine. And every single time I have any HCE who does not benefit, it lowers the coverage percentage that I need for the NHCEs. So for example, we start out with, if all of my HCEs participate, my HCE percentage is 100%. I need my NHCE percentage to be 70%. That means I can exclude up to 30% of the NHCEs. If I have 4 HCEs and 1 chooses not to participate, now my ratio percentage for my HCEs becomes 3/4 or 75%. The minimum ratio percentage for the NHCEs is 70% of the 75% or 52.5%. So by having 1 HCE not participate, I am immediately able to not cover a whole bunch of people in my NHCE group. So it goes down to almost 50%. So you can see that having an HCE walk away for coverage purposes is very powerful in terms of how many people you have to cover in the NHCE group. Next slide, please. So, okay, that's our background. Let's now talk about M&A. Okay.
You want to?
So,
would you like to take
I'm sorry, go ahead.
I was just going to say, do you want to take a couple of questions now, or?
Sure.
Okay, so the first one is there an exemption to the 30-day notice requirement to terminate a safe harbor plan due to acquisition?
I believe that, and this is a little bit off the beaten track kind of question for right now, but I do believe that would fall under the section of the safe harbor notice that deals with, it's supposed to be 30 days, or if it's not possible, as soon as possible. If you have an acquisition, so you couldn't give notice within 30 days, I believe it falls into the exception that says you have to give notice as soon as possible.
Okay. The next one is kind of long. It's a 2-parter. Do you want to wait till after, or?
Yeah, unless it's particularly, okay. Is it a coverage question specifically?
Not exactly.
Okay, then let's wait until the end,
okay.
or I'll answer it. Okay.
Okay.
All right, so let's talk now about the various transactions, because if you've heard me talk about M&A stuff before, you'll know that a critical element of dealing with M&A situations is to know what kind of transaction you have. So you must ask your client when they say we've had an acquisition or we've had a disposition, how did that occur? What type of transaction it was? And there are 3 possibilities. The first one is an asset acquisition. And in that circumstance, basically what has happened is that the buyer buys some of the seller's stuff. So for example, if I look around my office, we have computers, we have desks, we have client lists, we have accounts receivable, we have accounts payable, which are a liability. We have, all kinds of stuff. Somebody could come in and say, Ilene, I want to buy your company, so I want to buy your client list, I want to buy your desks, I want to buy your computers, but I don't want to buy your phone system because we already have a phone system. I don't want to buy your copier because we have plenty of copiers, and basically buy some or all of my stuff. If they buy enough of my stuff, then what's going to end up happening is that I'm not going to be in business anymore. So my employees are likely going to terminate employment with me. And that is a bona fide termination of employment. If the buyer wants to continue my line of business, they may require my former employees to join them and to become part of their company to service the former FBLC clients. And so they will begin employment with the buyer. This is a bona fide termination of employment and the hiring of new employees. And so those employees are considered to be new employees with the buyer of the company. And their eligibility and everything else starts from that date. There will never be a time in an asset acquisition where the two companies themselves are going to be controlled because there's no common ownership of the companies at all. All I've done is buy goodies for my office. So in the same way that if you decided to sell a computer that you no longer needed from your office to somebody who's walking down the street, that person does not end up with ownership in your company, neither would somebody who's buying my assets. In addition to that, the other part that's important to know is that the plan that I sponsored when I sold my stuff continues to be sponsored by me, and the employees are terminated employees and they become eligible for a distribution from my plan unless I do something to amend the plan to either have the buyer adopt the plan or change the distribution rules or something like that. So it's truly a termination of employment by the employees, a hiring by the new employer, and the plan stays with the seller unless the buyer chooses to adopt it as a successor employer. Next slide, please. The second kind of transaction is a stock acquisition. And when you talk about stock, you're usually talking in terms of a corporation. And basically what we have is a situation where I own 100% of the shares of the Ilene Ferenzi Corporation. I then sell my shares to Tim McCutcheon, and he now owns 100% of the shares of the Ilene Ferenzi Corporation. I might sell my company, the shares of my company, to, instead of Tim McCutcheon as an individual, sell it to Tim McCutcheon Inc., which is a company, which would mean that my company becomes a subsidiary of Tim's company. If Tim owns another company but he buys my stock individually, I would become a brother-sister company to Tim's company. So basically what ends up happening is that the company that's being purchased by the buyer becomes a subsidiary or a brother-sister entity if there's another company involved. So we automatically see that we have a control group issue that arises if there's any other companies that the buyer owns. Assuming that there is no affirmative change by the buyer, the employees will continue to work for the company, and they'll still get W-2s from the company, and they'll still participate in the plan of that company because the company has not changed. Like if I go and I buy 10 shares of IBM stock, you don't see headlines in the Wall Street Journal, Ilene buys IBM, because it's just the company stays the same. It's just that it has a new shareholder. Go ahead and go to the next slide now, Tim. Finally, the last transaction is an M&A transaction. That's a merger. And frankly, the easiest way to talk about a merger is to do it sort of in lay language instead of getting too technical. And so to me, what happens is the buyer and the acquired company smush together. That's not Latin, that's not anything, that's just Ilenese. They smush together to form a surviving entity. And I say here in this first bullet that it's by operation of law, and that is actually a meaningful phrase. What that means is that when two companies merge together, then everything just follows as part of the way the law works, and you don't have to take any further action. So that anything that's owed and owned or sponsored by either company now becomes owned or owed and sponsored by the surviving entity. So if Ilene Ferenzi Inc. owns the building and sponsors a retirement plan, and she merges with Tim McCutcheon Inc., and we become the Ilene Tim Company, the Ilene Tim Company automatically, without any further action, owns the building and is now the sponsor of the plan, regardless of what the plan says. You don't have to amend the plan. Now, most people do, to be clear, but you don't have to. It happens by operation of law. In addition to this, all employees of either of the two entities become employees of the survivor unless we choose to let somebody go or hire new people or whatever. But assuming that we don't do anything special, we just have our companies merge, then anybody who worked for me and anybody who worked for Tim becomes an employee of this merged company after the transaction occurs. And this surviving company sponsors any plan that was sponsored by either of the companies before the transaction occurred. Next slide, please. Okay, I already said this, so never mind. Next slide. Okay, service crediting rules are really weak, by the way, in M&A situations. They are very poorly sussed out in the law and in the regulations. The IRS looks at this periodically and thinks they ought to clarify, and then they can't agree on what to clarify, and so they just haven't yet. So don't be surprised by the fact you're going to hear me say nobody really knows a couple of times here. Now, in an asset acquisition, this is an area where it is very clear, and that's something I said previously, which is unless the plan provides otherwise, all employees are new to the buyer. They're brand new employees. They're new hires. The seller and the buyer don't relate to each other, and so everything starts from scratch. If you want to give those acquired employees service credit in the plan, you have to amend the plan to do so. Okay, next slide. In a stock acquisition, it's really not clear. So again, Tim McCutcheon buys Ilene Forenzi, Inc. The question is, do the years of service in the Ilene Forenzi, Inc. company count as years of service for the Tim McCutcheon plan that my employees may end up participating in? And the answer is really not clear. It is clear that if the Ilene Forenzi company, after becoming part of the controlled group, adopted a new plan, it would have to count all service for eligibility purposes for that plan, because there's no exclusion for pre-plan service for eligibility purposes. It's only for vesting. On the other hand, next slide, please. I will tell you that there are many, many people who take the position that when you talk about service for the buyer's company purposes, it's looking for service with that controlled group. In other words, for service with that entity. And so therefore, the plan that was sponsored by the buyer can exclude service prior to the purchase of the plans. And people do that all the time. So I know that there's like a logic gap here. Because if I started a new plan in Company B, I couldn't exclude that service, but somehow if they become covered under the Company A plan, we can exclude that service. It's just one of those magical, mystical things of retirement plans because the regulations are not clear. So there you go. Moving forward, please. With a merger situation, it's even less clear. Again, there are people who believe that you don't have to count service with either of the companies, unless one of the companies is the surviving company, because service with regard to that company relates to only the service after the merger. I find that really intellectually dishonest. It seems to me that if, by operation of law, everything that was owned and owed by each company becomes owned and owed by virtue of the merger, it would make sense that you would have to include service of both companies. Again, people make that argument. There's nothing in the law that clarifies, so I really can't tell you what the rules are. I just tell you what seems to make sense to me. Moving onward. So the question is there any way to exclude prior service for former Company B employees if the only plan to survive the merger is the Company A plan? And again, I'm uncomfortable with that, but people do it all the time. Moving on. Okay, so now let's talk about what happens when the transaction occurs and how you deal with coverage issues that occur. Next slide, please. Okay, in an asset acquisition, because the acquired employees in such an acquisition are considered to be new hires, there's really no 410B issue. These employees are going to work for the company that sponsors the plan. They will enter the plan when they meet eligibility requirements. If you want to, you can exclude those employees as a class, in which case you do have to meet 410B rules, but you need to be careful about how to do that. Next slide, please. The area where 410B becomes the real issue is in a stock acquisition. So suppose that Company A buys the stock of Company B. Company B becomes a wholly owned subsidiary and part of Company A's controlled group. When Company A does its 410B testing now, the Company B employees have to be included unless they're excludable because of age and service, union, non-resident aliens are terminated within 500 hours. So what we've got is a whole bunch of folks coming into this company that are in a group now, And for coverage purposes, they have to be in the coverage testing group. Now, that doesn't mean that the plan of Company A has to cover the Company B employees. It simply means that if it's going to exclude the Company B employees, it has to meet coverage. Moving on, please. So if we do that, if the Company A covers the Company B employees, then the RPT is going to be 100%, right? Because we're covering all the employees of the controlled group in this plan, we don't have a problem. But if we want to exclude the employees in the new acquired subsidiary or the new acquired brother-sister organization, now we can have a coverage failure, and it could be theoretically immediate. Next slide, please. There we go. So here we go. Stock acquisition. Buyer's plan covers the acquired employees. Suppose that Company A plan provides that there are no eligibility requirements and the plan covers any employee in the controlled or affiliated service group. The result is that all the folks that were in Company B are suddenly eligible to participate in the Company A plan, that everybody's in the same boat. There's no carved out group of people. There's no eligibility issues because we had immediate eligibility. And so voila, we have no 410B issue and life is good. And I don't know if your icon is blinking the way mine is, but I apologize for that. That doesn't usually happen. Okay, suppose instead that Company A's plan provides only employees of those affiliates who adopt the plan as a participating employer are eligible to participate, and Company B, the newly acquired subsidiary, does not adopt. And suppose further that Company A's plan has no eligibility requirements so long as you're in the covered class of employees. So we have a situation where all the Company B employees would meet the eligibility requirements, but for the fact that this plan has not been adopted by Company B, so they are excluded employees from the plan. Now we have a coverage issue, right? Now we've got a group of people who would otherwise be eligible. They're not excludable under the 410B test, but they are not able to participate in the plan. They're not benefiting, and so voila, coverage rears its ugly head. Next slide, please. Immediately upon the acquisition, then, the Company B employees become a non-benefiting group, and they may fail coverage. So we can have a situation where the minute that the transaction happens, before anybody's called you, they fail coverage. Next slide, please. Is it possible that it really happens like that you have to turn on a dime? And the answer is it would be, but for Internal Revenue Code section 410B6. So this is exactly the reason why this section exists, is to keep you from having to turn on a dime. What section 410B6C says is there is a transaction that causes a company to become or cease to become an affiliate in a group. So we've got a situation where our controlled group, our affiliated service group, our employer has expanded somehow. And the regulations are very broad in interpreting these transactions. It's basically any asset acquisition, any stock acquisition, any merger, or any disposition of any of those types. So people come in or people cease to be in our controlled group. And even if it's an asset acquisition, if we bring in a bunch of employees, but we want to now exclude those employees from the plan, the 410B6 rules would apply even in an asset acquisition. Okay. The second requirement is that the plan that we're dealing with had to have met coverage before the transaction occurred. Okay. If we meet these rules, then the plan at issue, the one that we're talking about, is going to be deemed to meet coverage after the transition occurs. So the plan at issue has to have met coverage prior to the transaction. Next slide. The third requirement is that there has to be no significant change in the plan or the coverage of the plan other than the acquisition or disposition during this transition period, and we'll talk more about that in a moment. If those three requirements are met, then the plan is treated as satisfying coverage during a transition period. Now, what will happen is a lot of people will say, okay, so if you do all that, then it just means that you have to pass coverage rules with the same group of employees that you had before and you can ignore the new employees. No. You get a buy from doing coverage testing, okay? You don't have to do any coverage testing during the transition period. You're treated as satisfying coverage. You're deemed to do that. So just to go over the three rules again, because I was a little bit unclear, I think. You have to have a situation where the plan met coverage before the transaction. You have a transaction that qualifies, and the list of transactions is pretty broad anytime you have an acquisition or a disposition. You don't make any significant change in the plan or the coverage of the plan. You get the benefit of this transition period. So let's talk more about that. Next slide, please. Okay, the period during which the plan is treated as satisfying coverage begins with the date on which the transaction occurs. And it ends not at the end of the plan year in which the transaction occurs, but the following year. So if we had a transaction happen today, October 17th, and we had a calendar year plan, Our transition period would begin October 17th and it would end December 31, 2018, the end of the plan year following the year in which the transaction occurred. So in our case, we'd have about 14 months during which we don't have to worry about coverage. Okay, next slide, please.
Question, if you have two plans, Company A and Company B both had a plan, one is a calendar year plan, the other is a fiscal year plan, the period would actually end on different dates for both plans, correct?
That is correct, and actually there's a slide that says that later on, but note that the transition period is unique to the plan. So if you have multiple plans involved, 1, 2, 3, 4, 5, 6, or 7, each plan in and of itself will have a transition period, and the period of time during which you need to meet the rules changes between the various plans because of the fact that their transition periods are different. Exactly. Next slide, please. So again, this is basically the same example I just gave you. A calendar year plan acquisition takes place July 15, 2017. The transition period begins on that date and ends December 31, 2018. Now, the transition period will end December 31, 2018. That's been interpreted by everybody to mean that we have to actually meet coverage for the 2019 year. Next slide, please. Okay. This is an important thing to note, and that's that the length of the transition period depends on when during the plan year the transaction occurs. So again, using a calendar year just to make it easy to illustrate, if our transaction happens in early January, we end up with a transition period that goes for that entire year of the transaction plus the following year, which is almost 2 full years. If, on the other hand, the transaction happens at the end of the year, we'll have 2 weeks for 2017 and then a year for 2018. All we have is about a year to have as a transition period. I have had the circumstance where when that's been set up, I've gone to the acquisition attorneys and said, is there a reason this has to happen in December or could it happen in early January? And they say, yeah, we don't care when it happens. We just chose December 31 for, cleanliness. And I say, hey, it would make my life significantly easier if this happened January 2nd instead. And they go, okay. And I buy myself a whole additional year to deal with the transition period. So it's something to think about if you are ever talked to about a transaction before it occurs, which we'll actually talk about later on. Next slide, please. This is the slide that talks about what Tim was asking. Each transition period applies to each plan separately. So if I have 2 plans, one that's a calendar year plan, one that's a June 30 year end, then the transition period is going to be different between the two. The transition period is going to end, the December 31 of the year following the year of the transaction for the plan that's got the calendar year, and it will end the June 30th of the year following the year of the transaction for the June 30 year end plan. New slide. Oh, and that's what that says. Next slide again. So let's talk about some of the fine points again. Next slide, please. Okay, one of the requirements, as I mentioned, is that there has to be no significant change in the plan or the coverage of the plan other than the acquisition or disposition. And what the effect is, if there is a significant change, is that the transition period terminates immediately and the plan has to meet coverage as of the termination of the transition period. So let's say that you had a transition period that went from July 15th to a year and a half later, December 31, and you figure out what you're going to do with regard to the plan 6 months after the acquisition, and you decide what you want to do is have the excluded employees enter the plan. So you do an amendment to your plan to change the coverage of the plan to cover the acquired employees. Well, boom, you have to now meet coverage, but you're going to do that because you amended the plan to include those employees, so now your ratio percentage test is 100%. So a significant change in the plan causes you to have to meet coverage immediately. If you want to do that, there's nothing wrong with that. You don't get slapped around just because you decided to meet the coverage rules early. You're fine. So just remember that that's the case. But now let's talk about what kind of changes actually will terminate your transition period. Again, there's no real guidance on point with regard to what constitutes a significant change. The actual law specifically talks about significant changes in coverage, so it would seem clear that if I do anything to change the group of employees who are covered by the plan, that certainly is a change that would cause my transition period to end. There was a change to that language in the regulations, which that's when we saw the language that said in coverage or any significant change in the plan at all. Again, there's nothing that tells us what that means. The IRS issued a revenue ruling back in 2004 that really didn't answer the question. It specified that a significant amendment of the plan's benefit formula is a significant change, but it didn't say anything else. So they had in an example, they said, we changed the formula from X percentage of pay to Y percentage of pay. Yeah, that's a significant change, so that will cause your transition period to end. But they really didn't say anything more. So basically, where do we end up with? Next slide, please. The answer is, since we don't know the answer to the question, the best thing is not to amend the plan at all during that transition period. So if you can avoid making an amendment during the transition period, that's the thing to do. You know that you're safe, and you don't have anybody diddling around with you about whether or not what you did was a significant change or a not significant change, which are very unspecific kinds of phrases. So if you can avoid amending the plan during the transition period, that's great. If you need to amend, finding some way to meet coverage under the normal rules after you do the amendment is certainly the safest way to go as well. But sort of doing an amendment and closing your eyes and hope nobody sees you and not meeting coverage is the worst possible way of dealing with that. So think about this in the most practical way that you can, and be as safe as you can, since the rules are not really clearly defined. Next slide, please. One of the issues that comes up, of course, is, oh my God, what happens if we need to do a restatement during the period? For example, if we had a transaction during 2015, so that we went to go do the restatement in 2016 for PPA, oh my God, we have to restate, we can't not amend. Does that automatically terminate the transition period? We've talked to the IRS about this informally. I've done it as part of the panels at ASPA. I've done it a couple of other times on a more informal basis, just chit-chatting. And what they've said to me informally is, if you do a restatement and all you're doing is moving from old plan to new plan, and you're not making any changes in the plan terms other than what are required by that modification from the old document to the new document, then that should not terminate your transition period. But if you are making any changes to the plan as part of that restatement, it probably would terminate the transition period. So you need to be very careful here, because usually, in my experience, when we do restatements for PPA and things like that, we don't do a lot of that anymore. We usually let the TPA do that. But when we do, we usually look at that as a great opportunity to change the way the plan is operating. If the client is having issues, you want to go ahead and sort of put that off, just amend the plan onto the new document and try not to change anything. Or, again, alternatively, deal with the change in the transition period at that, the coverage at that time, and make sure that you meet coverage once the change has been made. Next slide. Does a change to one plan terminate the transition period with regard to the other? So let's say we have a defined benefit plan and a profit-sharing 401k plan, and we do an amendment to the defined benefit plan. Does that mess up the 401k plan? The answer is no. Again, the transition period is maintained on a plan-by-plan basis, so the unchanged plan continues to be covered by the transition period, even though the other plan is not. Next slide, please. So consider the scenario. Company A sponsors a plan that covers all employees of the controlled or affiliated service group. The plan's eligibility requirement is 3 months. Company A acquires the stock of Company B. Prior to the time that the Company B employees will become eligible, Company A amends the plan to exclude the Company B employees. So we have an acquisition on day 1. The transition period would end on day 200. Sometime in that period of time, we amend the plan to exclude the Company B employees, and that will be before the Company B employees become eligible. What happens then? Next slide, please. Well, the effect is that the transition period ends, and the plan must immediately meet coverage rules. If excluding the Company B employees causes us to fail coverage, we got a problem, because now we have to meet coverage because we did that amendment, and now we're not going to, because we're excluding a group of people that's going to cause us to have a problem meeting coverage. So this is exactly the issue that we see come up. Next slide. What's the solution to this? Well, the best global solution is to be involved at the outset. Review the issue before the acquisition. Because the transition period starts with the transaction date, you can amend the plan all you want before the transaction occurs. So what people generally do is they look at what the plans say, and if the plan that they want to exclude employees from doesn't exclude them already, then they amend the plan before the transaction to say things like, from now on, any employer that has not adopted the plan is not eligible to participate in this plan, and that effectively excludes the acquired employees prior to the acquisition occurring. So the amendment is outside the transition period, and therefore we go into the transition period with the plans reading what we want to read, and we get the full benefit of the transition period. Okay, so that's the general thing that people do. Next slide, please. But as we all know, TPAs are not usually in the loop. And so what ends up happening is people come to you not before the transaction occurs, they come to you the day before the 5500's due, and they say, oh, by the way, did we mention that we did an acquisition a year and a half ago? So the question I always get is, what do you do then? And we're going to talk about what you do is resolve problems after the fact. But what I will tell you is that to me, the best way for you to solve this problem is to solve it ahead of time. And that means in your discussions with your clients, what you want to do is talk to them about the fact that if they decide to acquire a company or if they decide to sell their company, they need to talk to you before the transaction occurs. And I will tell you, with the stuff that we do for TPAs, we put this language in the service agreement that says you are required to tell us about M&A stuff, and we say in the service agreement, if you tell us ahead of the transaction, your options are much broader than they are after the transaction. I recommend you put it in your annual data request. I recommend every time you meet with the client, you bring that up again. Hey, you guys thinking of buying a company? Let me just remind you that if you do that, you want to talk to us. You just keep saying it to your client over and over again. And the goal is that when somebody is thinking about selling their company or buying another company, that little voice in their head, the little Jiminy Cricket in their head that tells them not to put their keys there because they're going to lose it, will say to them, oh my God, I better call my TPA and talk to them. I remember them saying that they need to know something before the transaction happens. And that will increase, I would hope, the number of times you get a call in advance. Now, I will also tell you, and this is the next slide, that generally speaking, if you have a client that is, I'm sorry, I guess it isn't there. I thought it was. If you have a client that does a lot of transactions, they will find religion the first time they screw this up, because it will be so miserable for them to have to correct it that they and their M&A attorneys will without a doubt figure this out, and they'll never not talk to you again. I will tell you that M&A attorneys, and I say this with all due respect if there's an M&A attorney on the line, if there's not, let's all giggle behind their backs. M&A attorneys tend to be sort of smug and believe that they're dealing with some of the most technical and hard to understand areas of the law, and they don't tend to want to listen to anybody else. So again, what you'll have on occasion is a M&A attorney who will blow you off entirely, and then they'll get completely messed up, and then from then on they'll listen to you. So don't be surprised if that happens. It's not unusual in the industry. Okay, so you have a client now that has gone through a transaction that came to you after the fact. Now what do? Well, some of the after the fact solutions is, first of all, amend the plan during the transition period and figure out how to pass coverage using one of the coverage tests. So you just look, the transition period screwed. What do we got to do to pass coverage? Okay. Next slide, please. You could try to enter VCP and get the IRS to permit you to amend retroactively to exclude the group that you wanted to exclude. That is a very hard row to hoe. You want to have some evidence of what the intent was. Lots of times you'll see language in an acquisition agreement that outlines that the intent was to amend the plan before the transaction or something like that. I will tell you that it's just not an easy process to do. If you have a very uneven transaction where you've got, IBM is the buyer and Itsy Bitsy plan covering 5 employees is the seller, and that Itsy Bitsy plan is after the fact supposed to cover all the IBM employees, you could probably get the IRS to agree that there was never an intent for the IBM employees to be covered in that Itsy Bitsy plan. But if you have a situation where company A with 20 employees buys company B with 15 employees, and you haven't dealt with this, it's going to be very hard to get the IRS to VCP that and fix it that way. Finally, the last solution is to cover the employees in the plan like the plan said. And if you didn't enroll the employees in time, do it afterwards for the late enrollment. Just treat it like a late enrollment and get those people in the plan. And again, the smaller the plan, the better it is to do this. Okay, next slide, please. So again, the key point is that the issue has to be dealt with before the transaction to provide the largest amount of flexibility. And this is where I had the slide that says people tend to find religion after one mess up. Next slide, please. Okay, before we go to questions, let me just mention one thing, and that's that if you have a client who is continuously doing acquisitions, acquisition 1, acquisition 2, acquisition 3, you're going to end up with overlapping transition periods. And if you do an amendment to coverage to solve one transition period, it will screw up your transition periods for the other acquisitions. So consider with a company that has a lot of successes acquisitions, talk to them in principle about what they want to do with the acquired employees and put that language into your plan. so that the plan will operate without an amendment to do what they want to do. So for example, you could have a provision that says, we exclude any 410B6 employees until the transition period ends, and then we let them all on the plan. Then you're going to have a special entry date for these people, but it's already in the plan document. It doesn't require an amendment, and it doesn't screw up your transition period. Okay? So with that, do we have any questions?
Oh, do we have questions?
Okay.
we have a tremendous amount of questions, first off. Let me just say to the audience that and thank you for your questions and your interest. This is obviously a great topic. Many of the questions that we've received are far too detailed for, I think, Ilene to answer in general for the whole group. So and some of these look very good, so you might want to perhaps drop Ilene an email or talk to her at some point. A lot of them are just very specific and have a lot of moving parts, shall we say. But there are other ones that are a little bit more general. So let me kind of dive into those. What is the proper method to use the fail-safe provision to pass 410B?
That's a really good question, and I really intended to talk about that a little bit and forgot to do so. Many plans have what's called a fail-safe provision in it that says, if this plan fails 410B, and for example, this could be any failure, it doesn't have to be necessarily involved with an M&A transaction, but it's an outlines of method by which to meet the 410B testing. So it'll say things like you're supposed to bring in employees who are otherwise excluded by who worked for the company the longest, or by what, the people with the highest comp who are not HCEs, or something like that, or the lowest comp that are not HCEs. If you have a fail-safe provision in your plan, you must follow it. Let me also mention that if you have a 410B failure, you have until 9.5 months after the end of the year to fix it. Now, if you're going to fix it by excluding people, you can't take the whole 9.5 months because you have the anti-cutback rule. But the point is, if what you want to do is trickle in enough employees to fix the plan, then if you don't have a fail-safe provision, it allows you to be very discretionary about who you let into the plan. So you decide to let this guy in and that guy in and the other guy in. This is where that rule that Tim mentioned about having to have a meaningful benefit comes in. Let's say, for example, that your plan has a last day requirement and you've got a bunch of employees who work more than 500 hours. So you say, okay, we'll put them in the plan and they'll be in the plan, but they're not going to get a contribution. Well, you can't do that because those people don't get a benefit, so they're not benefiting. So you say, okay, well, I'll tell you what, all those people that had, the less than 1,000 hours, we'll give them a benefit of $1 a piece. Well, again, that's not a meaningful benefit, and so the IRS does not respect that. So you need to make sure that whoever you bring into a plan for a benefit is going to get enough of a benefit that you're not going to get laughed out of the room by an IRS auditor, okay? So basically the moral of the story is that you have to follow what the fail-safe language says. I'm not a fan of fail-safe language, to tell you the truth, as long as the plan is subject to having a CPA look at it in time to be able to make the proper corrections within the 9.5 months.
Okay, another question was, where does the same desk rule fall with acquisitions?
In general, the same desk rule no longer applies. It was taken out as part of EGTRA. There's only one time that the same desk rule applies, and that's with a disposition of a subsidiary that participates in the plan of the parent. So you have a situation where, I'm a subsidiary of Tim's. I participate in the Tim Inc. retirement plan. My subsidiary is sold to somebody else. The rule is that we cannot pay out the Ilene employees unless all three of the following are true after the sale. First of all, that we sell to an uninterested party, so we don't sell to another part of the control group. Secondly, that nobody in the plan that was participant in the Ilene company continues to participate after the transaction occurs. And the third is that we don't do any kind of spin-off from the Tim plan to the Ilene plan. Now, the second requirement, the one where I don't continue to participate after the transaction, if we have a situation where the way that I am participating in the Tim plan is that I have signed an adoption agreement as a participating employer, if I don't stop that participation before the transaction, then my people will continue to participate in the Tim plan, and the Tim plan becomes a multiple employer plan at that point. Once that occurs for any time at all after the transaction, then the same desk rule kicks in, and the Ilene employees cannot be paid out until they terminate employment with Ilene. So you have to be very, very careful about that to make sure that that occurs. And if you want to talk about that further, give me a call or send me an email and we'll talk further.
Okay, another question. Can you generally speak to merging non-safe harbor into a safe harbor plan or even safe harbor to another safe harbor plan mid-year?
Yeah, you know, my general rule about merging safe harbor plans during the year is just don't do it. As you know, the IRS has now ruled in large measure that you can do a lot of amendments to safe harbor plans mid-year. The problem is that there are many moving parts to that, and almost all of them get invoked when you're dealing with a safe harbor merger with a non-safe harbor plan or two safe harbors merging. So if you don't have two like plans, meaning, you know, if you have a 3% QNEC plan and a 3% QNEC plan and everything is pretty much similar about the plans, that nothing is going to change when somebody merges into the other plan, then you can do it. But if you're going from a safe harbor plan, 3% QNEC plan into a matching plan, that's a problem. If you're going from a regular safe harbor plan into a QACA plan, that's a problem. And if you're going from a non-safe harbor plan into a safe harbor plan, that could be a problem. So my quick and dirty answer, not looking at the facts of a given situation, is just say no. Merge at the beginning of the year.
Okay. Let's see. Another question. Company A acquired Company B in April of 2017. Company B has a terminated plan and failed their ADP test for the short plan year 1/1 to 3/31. Can the employees' refunded excess contributions be deferred into Company A's plan for 2017?
Oh, yikes. I need to think about that.
Okay.
I'm sorry. Send me that in an email and I'll look at it.
And perhaps again, that person that sent it in, there might be other things that kind of go with that.
Ilene, I think the answer is pretty clearly no, isn't it? That it's not a cash or deferred election. You just can't.
I would think that the answer is no. Yeah, I mean, I would agree with you that I would think that the answer is no, and I would think that what they could do, of course, is make an election in the new plan to defer the same amount.
Right.
You know, but I just, yeah, I clinched. Sorry, my butt cheeks tightened when I heard that question. What can I say?
Okay, another question, can you layer transition rules for multiple transactions?
Yes, as I mentioned, you definitely can, but you have to be very careful because if you have to do an amendment for the first transaction, that amendment is going to terminate your other transition rule. So you're better off if you have a series of transactions, thinking about it globally and putting something in your plan about how to deal with transactional employees so you don't have to do individual amendments. And you can be pretty creative in that amendment as well. For example, you could say, and I've seen this happen, if we do an acquisition and the number of acquired employees exceeds 50, then this is what's going to happen, and if it's 50 or less, this is what's going to happen. And again, so that you don't have to amend the plan, and without an amendment, you don't terminate the transition period for the other transaction.
Okay. Probably time for one more question. What happens if a company acquires another company during the transition period of the first acquisition?
Again, that's fine, as long as you don't amend the plan.
Okay.
So you just have a second transition period with regard to this second group of employees.
Okay, I think that, Tim, what do you think is about it? I mean, again, there's many more questions, but again, so many of these are very detailed, and in this, I think you'd agree, Ilene, in this subject matter, you know, an I might not always be an I, so I know it's very important to really look at all the different facts and things. So, you know, we would welcome anybody to contact Ilene. I think, Ilene, as you had said earlier, it might be something that you can answer relatively quickly or something that perhaps someone needs to engage your firm for. But again, it's kind of in this kind of forum, it's difficult because there just are a lot of different working parts with a lot of these questions. And again, some of them are very good, but some of them are six-parters and very detailed. So probably not for the general.
Let me just encourage everybody to go ahead and send it to me. And you're going to forward these questions to me, and we'll post the answers that I can answer on the website, right?
I think really what we had decided was that we would just try to get to as many as we could during the webinar,
Okay.
and then really cover the material for the bulk of the audience, and then really just invite anybody to contact you either again to talk about it, or again, if an engagement is needed, then you would let them know that.
Okay, then by all means email me, guys. The worst that could happen is I say I can't help you unless you hire me, and that I tend to be kind of a wimp about that, so please send me a note. All right, you guys want to do your thing, yes?
Okay, thanks, Eileen. We will get started here on the demo for erisapedia.com. Please stay on with us if you have just a couple of minutes.
You should have the power.
Okay, hopefully you can see my screen, which is the dashboard for erisapedia.com.
Yes.
All right, erisapedia.com includes several titles that are helpful to retirement plan professionals. It also includes government source material, the IRS, DOL, PBGC, all the statutes, regulations, and other helpful information. I will briefly cover our qualified plan e-source that is written by Eileen. So the qualified plan e-source is a 21-chapter book. Each chapter includes a detailed table of contents to make it very easy to find what you're looking for. The e-source also has an appendix that has very valuable information like plan limits, VCP forms, and also several worksheets that help you to perform certain testings. Eileen has devoted an entire chapter, chapter 20, to mergers and acquisitions. And as you can see from the table of contents, as I scroll down, that a lot of the information that she covered during our webinar are also included in this section. When I click on coverage, you will see in this particular chapter a lot of the things Eileen covered. Anything in blue is going to be a direct link to source material. In this case, it's 410B, section 6C, and it will take you right to that particular section so you can read the accurate code, but very easily go back to where you were in the chapter and find your spot. As I scroll down here, you will see that Eileen has included numerous examples and situations that help you apply those rules to your situation. The entire qualified plan e-source is written in this format, always includes direct links to source material, very easy to navigate. If any of you would like a more personal demo, we can take you into a lot more detail and actually show you how to use our powerful search bar and other things. Please give us a call at 612-605-2266, or you can always email us at support@erisapedia.com. This concludes our webinar today. Thank you very much for joining us, and we look forward to having you join more in the future. Bye now.